We keep this defibrillator ready and charged in our law office in the event of an emergency. Hi, I'm Darren Findling from the Probate Pro, and hopefully we'll never have to use such an important life-saving device. I'm going to spend some time speaking about a particular document that's relevant to using a defibrillator or CPR or extreme measures when somebody no longer is desirous of having these extreme measures provided to them because of their particular life circumstances. We're referring to a Do-Not-Resuscitate order. Now in Michigan, these Do-Not-Resuscitate orders are available at most hospitals, nursing facilities, medical centers, so that you can fill them out while you're competent, and of course well before the emergency scenario would exist, to allow you to state your preferences. Now in an estate planning context, a good estate planning lawyer is going to ask a question of you about all sorts of medical related desires about how you'd like to be treated at the end of your life. Including in that would be a do not resuscitate order and whether that applies to something that you'd want. There's no requirement, of course, to sign a do not resuscitate order, and there are some people who believe that all extreme measures should be taken to prolong the life, and of course there are others who don't believe that that's the case. And in Michigan, we allow for people to have their decisions be expressed in writing so that rather than a hospital person or a stranger or somebody else making the decision about your end of life, you get to control it. It's a really valuable thing. Now, if you sign one and then you change your mind, you can revoke it. It's not like it's a document that is permanent. And of course, you can have variations of where you are in your stage of life as to whether you want that to occur or not. And in our website, within this video, there should be a whole bunch of frequently asked questions that I've addressed specific circumstances about the Do Not Resuscitate order to give you greater context of how to use them, where to find them, and the implications relative to them. In the probate context, often a guardian is asked whether they will be willing to sign a Do Not Resuscitate order on behalf of the person that they're serving as guardian of. And just a few years ago, there was no statute that addressed this particular issue, and now thankfully there is. A guardian can execute a Do Not Resuscitate order, but there are very specific requirements that that guardian must go through before doing so. And it's critical that you review the statute, as well as on our website we've identified it, to understand what steps must be taken by a guardian in advance of signing a Do Not Resuscitate order. It's not as simple as just signing it at the hospital. It's much more extensive, and it requires even a waiting period before the document could come into effect. Now, these types of issues are quite sensitive to people, and often in a hospital context, it's really the worst place to be faced with the decision of whether to sign a document like this or not. So we strongly recommend that you meet with your estate planning lawyer. You're welcome to call us at the Probate Pro to have discussions about whether a Do Not Resuscitate order is appropriate under the circumstances that they're faced in. And hopefully a life-saving device like this defibrillator would never be needed to be used, but really we're protecting against a reality that exists at the end of many people's lives. If you've got more questions about Do Not Resuscitate orders or any estate planning related issues or probate issues, call us at the Probate Pro, 877-YOUR-FIRM.